So question for you. So you mentioned it earlier, and you're a DPO for many organizations. You mentioned GDPR requires a DPO under certain contexts or constructs. How about the other regulations? So if I want to be CCPA compliant, do I need a DPO or someone who's specifically assigned that title? Same thing with APAC. Talk a little bit about the DPO, and then also I think most people don't understand what a DPO's role is. And there's, I think, a prescribed role, some of that stuff about liaising with the data privacy agencies and things of that nature. And I think there's the non-prescribed roles that I think are the ones we struggle with, right? Clients coming to us and saying, oh, the law says this, does this meet the law, right? So a great example that I think a lot of people listening or reading this would recognize is, oh, a client walked up to me at a trade show and they gave me their business card. Is that explicit consent? Or we send a newsletter out and it says, if you want to unsubscribe, or click here, is that the fact that they didn't click here, is that explicit consent? And does that meet the requirement, right? So this interpretation of laws, regulations, things of that nature, new pronouncements or whatever the right words are. Talk a little bit about that DPO role and what the value prop is, why you have to have one in certain laws, and then what the value prop is to having a DPO.
Okay, so here's the thing. We know that this awareness of privacy has exploded, and we touched upon it right at the outset. Individuals care about the information that is held about them within organizations. So this is going to be one of the kind of the defining issues going forward as we accelerate digital if you like progress, because we're all going online now, we're ordering things online, and our lives have become very virtual. So that's a direction of travel. It's not going away. There are new laws emerging in different regions around this topic. How do you manage all of that within an organization? Understanding that, yes, this is a board level issue, and you have different functions that bring different perspectives. So we talked about the security function, the compliance function, maybe the legal function, the product teams. So you've got all these different functions that will have a particular view and perspective. What's really helpful is having an individual or a team who have specialism in this area, actually advising on, in a very objective, independent way, compliance. And so, ultimately, that's the role of the DPO. And it's hardwired into the GDPR. And it was recognized as one of the ways in which you can, as an organization, demonstrate your accountability by having this independent specialist team or individual who can advise on compliance. And as you mentioned, interface with individuals, whether they're employees or customers, and the supervisory authorities. Now, in terms of, what about the legislative frameworks? The CCPA doesn't mandate that you have a DPO, but ultimately, if you're a global organization and you're operating across different markets, Europe, US, APAC, Africa, having a DPO who's cognizant of the global requirements is only going to benefit you as an organization. And I mean, fundamentally, you have to do your analysis on whether you have a mandatory obligation to appoint one. And if you're going after the European market, right, so you're targeting individuals in Europe, you need to think about, well, actually, what are my compliance obligations? And do I have an obligation to appoint a DPO? If you operate in the tech space, health tech, fintech, if you're processing huge volumes of information about individuals, then you have to do your analysis on whether you have an obligation to appoint a DPO. And even if you don't fall under that mandatory bucket, given the direction of travel, given all these requirements, you perhaps have to seriously think, does it make sense to have a specialist, individual or team that can advise on what our obligations are and also support us in triaging on some of the gray areas that you mentioned?
Right. Two things that strike me as when I heard you speak is, first off, anyone listening that says, if you're a global organization, that doesn't mean that you've got people in 7 continents. That means that your products or services are consumed globally. So like many of our customers are startups, 10-person, 20-person, 50-person, 100-person organizations are global, right? Because they're providing goods, services, especially as you're a technology company, any software as a service vendor, if they're a global organization. So don't listen to Dyann say the term global and think, we're not a global organization. We're based out of, out of Massachusetts. No, you're a global organization if your customers are global. So that definition of global, right, is, are you addressing a global market, correct?
Yeah.
Okay, good.
Yeah.
Second thing is that I'd be curious about, and where I see the struggles are, the kind of questions I asked you before about, is that explicit consent or not? Or the other thing is like I don't know what the right legal term is, but when the CCPA, the California Attorney General, is constantly releasing, I don't know what they call them, clarifications, pronouncements, or these addendums, and these clarifications, like the original law is 156 pages, and the clarification is longer than the original law. And it tends to muddy the water. So as an example, they had, I don't know, 18 pages on validating an individual's, or something crazy like that, validating who an individual is before you service a DSAR, right? And what's the right way to do that? So my understanding would be that my DPO is the person who I'm going to go to as the technologist, or I'm going to go to as the COO of the organization and say, what does this mean? And how do we implement this in our organization in a way that keeps us safe? Is that fair?
Yeah, and I think the DPO is there to advise, is there to advocate on your behalf, and is there to be very pragmatic, right? They understand your business, they understand your services, and they have to help you to operationalize these requirements, as you say, in a way that makes sense for you. Now, often the DPO is providing that oversight role, so they're not actually the ones that are making the decisions around the processing of information. And one of the key requirements is that the DPO has to be sufficiently independent in order to be able to properly fulfill their duties and responsibilities. And you mentioned that there is specific statutory role that the DPO plays. And then there is this the slightly more nuanced role around advocacy on behalf of organizations, horizon watching, advising an organization. But ultimately, they're there to ensure that you meet compliance with your legal obligations. And they have to do so in a way that is free. And I use the analogy of a referee, a coach, and a player. Right? So, as a player, you can't be the referee, because, effectively there will be an element optically of bias. You've got two sides playing, one player on a side cannot be a referee. If you're a coach, that's a very, very different role to being a referee. And I would associate a coach as being the privacy office, or the chief privacy officer within an organization. You're kind of looking to see what the strategic opportunities are for the organization, how you're able to meet those strategic opportunities around data, but you're not necessarily acting as a DPO. The DPO is effectively the referee. The DPO needs to be able to blow the whistle to say, well, actually, no, there's a red line here. This is something that would be contrary to your obligations. and it's a no-go. Now, as an organization, you can accept that position, or you can challenge it. You can say, well, we're going to take a risk-based approach, provided that you document that and you're able to demonstrate the sort of the considerations that took place in arriving at that position. Fine. And really, there are opportunities that for a DPO to report to a supervisory authority. But those requirements are very sort of strictly laid down. And it would be quite rare, actually, that you would find a DPO not coming to some form of agreement with the organization for whom they are acting as a DPO. So you can, record your, and this is where processes and, if you like, documentation, like your data protection impact assessments are really helpful. So you set out the processing that you're engaged in, you set out the risks associated with that, you set out the DPO's advice, and you can either, choose to follow it or not. But that's all very clear, very transparent, documented. And that gives you then a basis to move forward as an organization.
Yeah, I never really thought about the value proposition of having a DPO during that DPIA. But for anyone listening, data privacy impact assessment, that's what we're referring to. And if you're not a privacy person, it's the equivalent of a risk assessment that's focused on personal information, right? Like information security people do risk assessments. We don't do DPIAs, but it's basically a risk assessment for personal information. Yeah, it's ostensibly the same thing. And I think most people, especially we do a lot of work in ISO 27001, as you might know. And ISO 27001, we have the same exact concept there, which is really interesting to me. We have this concept of you conduct a risk assessment, and there's ISO says you should have these 114 controls, and they should be implemented in accordance with risk and context. And you can say, I don't need that one. And an auditor might disagree with you, but if you've documented in your risk assessment fairly and reasonably, you've followed the right process and you've got the evidence to support, then you should be okay. So it sounds like it's the same situation here, and the DPO would have the added value of being able to, if you are going to accept a risk, which would not be that a knowledged individual would look at your decision and say that's not consistent with prevailing wisdom or good practice, the DPO would be that person that would do that. So I could come to you with my DPIA and say, here's what we're going to do. And you would say, check, 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 check. Ooh, you know what? Not having locks on the door and accepting that risk. I know that, that would save us from having to spend money on a locksmith, but probably not a good idea. And if you did have an action by a DPA, we're going to end up in the Hooskow for that one, right? Hooskow, by the way, in the U.S. is a term for a jail. You English people, I always got to translate stuff.
Indeed.
So that's another value proposition, right? I mean, I would imagine you'd be very, very helpful while we're reviewing a DPIA.
Absolutely. And actually, there is an obligation to consult a DPO and seek their opinion when completing a DPIA, because you have to involve them in decisions around processing of data where there is a risk to the rights of individuals. So,
Right.
Ultimately, DPOs must and do input into the DPIA process.